Good evening, Madam President and members of the council. I'm Artisha McCullough, and I am the Director of Employment Investigations and Civil Rights Compliance, and I'm here to talk about employment investigations and civil rights and just a general overview of some of the things that our office does. Next slide, please. Employment investigations and civil rights compliance oversees, administers, and enforces the City of Oakland's Equal Employment Opportunity Policy, Administrative Instruction 71, Title VI compliance. The city's Equal Employment Opportunity Policy is intended to ensure that all employees have a work environment that is free of conduct that could be considered discriminatory or harassing based on a protected status. Our office also provides training to city employees based on AI 71 and other discrimination and harassment matters. We also provide statistical reports, we testify at legal proceedings, and we also respond when state or federal government requests a statement with complaints that they have received from our employees. Next slide, please. Why equal employment opportunity matters. It's the law. For one, we are mandated to address employment complaints involving discrimination and harassment. It's also city policy. It's good for recruitment, retention, and morale, and it's also the right thing to do. Next slide, please. Authorities and sources of laws with regard to discrimination and harassment. Under federal law, we have Title VII of the Civil Rights Act of 1964, Title VI, the Equal Pay Act, Age and Discrimination and Americans with Disabilities Act. Under the federal government, under states, we have California Fair Employment and Housing Act. City of Oakland's Policy Administrative Instruction 71 is in alignment with these two laws. And so we created AI 71. And also the city has a separate code of conduct, and I'll distinguish the two as we go on. I'll just briefly talk a little bit about some of the acts. Title VII of the Civil Rights Act prohibits employment discrimination on the basis of race, color, religion, sex, or national origin. The Equal Pay Act requires that men and women be given equal pay for equal work. And the Age Discrimination in Employment prohibits discrimination and protects certain applicants and employees 40 years of age or older. Americans with Disability Act prohibits discrimination against qualified individuals with disabilities. And those are all state laws and state acts. Under state law, those are all federal laws, sorry. Under state law, we have the Fair Employment and Housing Act. This was enacted in 1959 and was signed by Governor Brown's father. It prohibits discrimination in employment on a number of protected bases, and I'll go through and show some of the protected bases. Next slide, please. You can go to the next slide. I kind of covered that one. Thank you. So AI 71, Administrative Instruction 71, it outlines the City of Oakland's policies, standards, requirements, complaint procedures, and disciplinary guidelines regarding inappropriate and professional conduct that could potentially rise to the level of discrimination or harassment. It also sets out our investigations procedures. Next slide. Who and what the policy covers. All full-time employees, part-time employees, temporary employees, interns, volunteers, contractors, and job applicants. The policy covers all terms and conditions of employment, including but not limited to recruitment, hiring, promotion, termination, discipline, layoff, recall, transfer, leaves of absence, position classification, training, compensation, and benefits. Next slide, please. These bullets show a listing of different types of conditions, employment conditions. So there's hiring, awards, performance evaluations, harassment, retirement. One of the main employment conditions that we hear about often and receive most complaints about is hostile work environment. So I'll go into a little bit of what would be considered a hostile work environment. Next slide, please. So a hostile work environment can include intimidation, abusive or offensive conduct based on a protected status. A hostile work environment can be created by anyone, not just supervisors and managers. It could also involve pranks, jokes, ridicule, stereotypes. Okay, you can go on to the next slide. And I mentioned that I would talk more about state law and protected status. And we focus more on state law because it's more broad. It shows more protected status than federal law. It covers more protected status than federal law. So these are all the protected status that were created by the state Civil Rights Department. And so it's race, color, ancestry, immigration status, religion, creed, age 40 and over, disability, sex, pregnancy, breastfeeding, sexual orientation, medical condition, genetic information, and so forth. So these are all the protected status that were set forth by the state of California. So when we look at when a complaint is filed and we look at the basis of a complaint, it has to follow under one of these categories. Next slide. So when we're assessing a complaint, when we look at an issue, we talked about for example, the hostile work environment, and we look at a protected basis. In order for the matter to fall within our jurisdiction, there needs to be a nexus between the issue and the protected status. For example, the issue could be I was denied a promotion. And the basis, I believe, is I say it was because of my age. And the nexus would need to show that that's pretty much how you set it up. But if you wanted to show a nexus, you then would need to provide some examples of why you believe it was because of your age. Another example would be, I was denied promotion. I believe it was because of my age, and I'm aware that younger, less experienced employees were given promotions and I wasn't. That's the situation that we would assess and determine if this jurisdiction, if it would require an investigation or some sort of a matter to resolve. The next slide. So we'll go into sexual harassment, talk about sexual harassment. Next slide. There are two main types of harassment that we look at, and that the state and federal government looks at. The first is unwelcome conduct. It's a hostile work environment harassment. Unwelcome sexual advances. These could be visual or verbal, physical. Can involve creating an intimidating or hostile or offensive work environment. These are the most common types of complaints we receive when we receive sexual harassment complaints. The other we receive less often these days, and this is a quid pro quo, and it's basically a a favor for a sexual advance. Next slide. Under federal law, under Title VII of the Civil Rights Act, an employer is vicariously liable for sexual harassment by supervisors. An employer can be liable under a negligence theory for sexual harassment by non-supervisors if the employer knew or should have known of the misconduct. Under California law, Fair Employment and Housing Act, an employer is strictly automatically liable for harassment by supervisors. An employer is liable under a negligence theory for non-supervisors and non-employees. Also, supervisors and non-supervisors can be held individually liable for sexual harassment. Supervisors can also be held individually liable for aiding and abetting the harassment. So when we're looking at sexual harassment in that area, go back right quick, under California law, it's more strict, and it's important to note that if a supervisor harasses an employee, the city is automatically liable for the harassment because it's considered that the supervisor or manager is an agent for the city and should know better. And also is important to note also that individuals can be individually held liable for harassment. So if an employee harasses another employee, that employee can sue that employee, not just the city, can sue that employee individually, and that person would be liable individually. For those reasons, beside mandates, we do provide sexual harassment training. The state does require that all employees receive sexual harassment training every 2 years, and we do offer that. We keep track of that through our training department and through some of our oversight. And so, that training requirement is for all employees. It's also required for any contractors, any interns, commission, council, and so forth. That's every 2-year training. Currently, that training is being provided online. We also when we do trainings, and for our academy and our standalone trainings, we also do a portion of sexual harassment training as well. Next slide. Retaliation is another area that we look at. It's expressing a concern about discrimination or harassment, filing a complaint, whether with our office or with the state or federal agency, or opposing practices that violate city policy, or just by simply cooperating with an investigation. All these areas will be considered retaliation, and they are protected. Retaliation is any inverse employment action such as discipline, demotion, or discharge in response to a protected activity. Typically, it's shown by the timing of an employment action, and it's usually circumstantial evidence that's received. We require, and a city policy requires, that anyone who observes or otherwise become aware of a possible violation can complain. Managers and supervisors with knowledge of any possible violations of our administrative instruction 71, they must report it. We consider it a violation of policy for supervisors and managers to not report any violations that they become aware of. There are times where matters come up and they're not reported immediately, and by the time we receive them, the matter has become worse, or they've placed the city in a situation where there's more liability. So it's very important that managers and supervisors, or anyone with knowledge of a possible violation, should report it to our office. Here, complaints can be initiated either verbally or in writing. And when I walk through our process, I'll talk more about how we receive complaints and what we do with them. So our investigative process is, first of all, we receive a complaint. We may receive a complaint through our website. We can receive a complaint for someone coming to the front desk of HR and dropping off a complaint and it being forwarded to our office. We may receive a complaint through an email. We may receive a complaint through a referral from another department. Those are the typical ways. We may receive a complaint through regular mail. Those are the typical ways we receive complaints. Once our complaint is received, one of the investigators will do an intake. That intake involves sitting down, or whether it's over the phone or over the Zoom or Teams, and determining what the issues are and if those issues fall within our jurisdiction. If they fall within our jurisdiction, we'll determine if it's a matter that we can resolve immediately or if there needs to be a formal or informal investigation. On a lot of matters, we do try to resolve them informally without an investigation. Sometimes there's a matter where there may be some inappropriate comments, and we can resolve that immediately. We can go over training and counseling with the individual and resolve that matter. Other issues with regarding sexual harassment or other types of more serious matters, we conduct a formal investigation. But we don't, oftentimes people will refer matters to our office and ask us to investigate it. Every matter doesn't require investigation, so we ask people to not tell individuals that a matter will be investigated. Some matters, like I said, we can resolve informally, or we can resolve through counseling. So let us determine and let the individual know whether we've determined that a formal investigation is required. If we determine that the matter is not within our jurisdiction, we will refer it to the appropriate department or agency, or we would advise them on what they may want to do. If we do determine that it's within our jurisdiction, as I mentioned, we will conduct an investigation, or we will try to resolve the matter formally or informally. When there is an investigation, at the conclusion of the investigation, we do write a full investigative report, put together a summary. We will meet with the person that filed the complaint and review the findings, and we will issue a closeout notice to that individual. We also issue a closeout notice to the person that was complained against. And depending on the matter, we will submit a report to the department, not a report, but a summary to the department. Sometimes we let departments know what the findings are, and we make recommendations based on what the issues were and if there's some further action that needs to be taken. Our investigation process is confidential. We discuss these matters on a need-to-know basis. Confidentiality protects all parties involved. It's so very true that fewer people knowing also reduce the risk of retaliation. Sometimes individuals think that someone else is aware that they filed a complaint and that they're being retaliated against, when that information, as far as we know, may not have been shared. We do tell people, especially witnesses that we've interviewed, to not share information about the case to others, to keep it confidential. It's also important to note that once we conduct an investigation and we make findings, we are required to conduct a good faith investigation and good faith findings. Individuals are not always happy with our findings. And so if they disagree with the findings and we've met and discussed it and we're not able to resolve their concerns, they have the right to file with any of the agencies that I've mentioned before, the state civil rights department or the federal EEOC, Equal Employment Opportunity Commission. Employees also have a right to go directly to those agencies. They don't have to come to us. Those agencies would prefer that they file those complaints with us first. But if they're not comfortable, or for whatever reason, they want to file a complaint directly with those agencies, they have the right to do so. And we will often receive a request to respond to the complaint. If should an employee decide to go to a state or federal agency, that agency will ask us to respond, to put together a formal response with regard to the complaint. Next slide. As I mentioned, managers must report allegations of harassment and discrimination. We ask that they not assume that someone else will report it. Even if someone has reported a violation or reported a concern and they want to let it go, we still ask that managers and supervisors require them to let us know and to report it. All allegations of sexual harassment complaints must be reported to our office, just to make sure we know about the issue. And here's our staff. Currently, we have, we call them specialists, 2 investigators, an admin assistant, and myself. And we are budgeted for 1 more position, currently budgeted for 1 more position. That's it.
Thank you so much for joining us. And thank you for all of that important information. Colleagues, please raise your hand if you have any questions, comments, or clarifications. Okay, I'm not seeing any hands up. And we do have all of yours. We have the staff's names, phone numbers. I'm sure we can find them on email.